Very good. I'm glad you could make it, Ms. Floyd.
Thank
All right,
you,
let's
Judge.
get started then. This is a hearing in Civil Action 2021V0015 in the Superior Court of Burke County in the Augusta Judicial Circuit. It's the case of Maureen O. Floyd against Jesse Stone. I am Senior Judge Michael Karp. I am presiding by designation following the voluntary recusal of the judges of the Augusta Judicial Circuit. By earlier stipulation of the parties, the hearing is being conducted electronically. The petitioner and her lawyers are in their offices in Augusta. The Attorney General's office representatives, I assume, are in Atlanta. I am in Savannah. The hearing is accessible to the public in a courtroom in the Burke County Courthouse where Sergeant Jones is at the controls, so to speak. I still think it might be available by live stream based on an email I got earlier today, but regardless, it is available to the public. The parties have stipulated that there are no factual issues to be resolved, and the case is ripe for disposition either by granting the respondent's motion to dismiss or by granting the petitioner's application to file for the writ of quo warranto. I failed to mention that I'm being assisted in this hearing by Staff Attorney Kara Mobley, who has her camera turned off, but she is a brilliant staff attorney from Savannah that I worked with for a number of years, and she's gracious enough to give me some assistance in this case. One other thing I want to mention before we get started, OCGA 96-64 requires that the ruling be rendered within 10 days of the proceedings. I'm considering the 10 days to start as of today's hearing, so you can expect an order within the 10-day period. So with that, the motion that's outstanding, I think, is the motion to dismiss filed by the respondent. So Mr. Willard is here for the Attorney General's office, and Mr. Stoy. I guess, Mr. Stoy, you're going to address the issues for the respondent. The petition is represented by Mr. Rhodes and Mr. Amos, both of whom are also on the call. Mr. Willard.
Thank you, Your Honor. May it please the court, my name is Russell Willard, and along with Lee Stoy from the Attorney General's office, we are here on behalf of Judge Stone today. This is a straightforward case involving application of clear constitutional text and a plethora of Georgia Supreme Court cases, some quite recent, dealing with the issues that are pending before the court today. Accordingly, we therefore move this court to dismiss, or in the alternative, deny Floyd's petition because neither of their endeavored amended petitions nor their original petition avoid the fatal flaws inherent in their arguments as to why this court should depart from the clear constitutional text authorizing Judge Stone's appointment. This case and the method for filling judicial offices in Georgia can best be understood as analogizing to Robert Frost's proverbial two paths diverging in the woods. The path is not selected by the traveler, as in the Frost poem, but instead by the predecessor to the successor in judicial office and the actions taken by that predecessor. If the predecessor in the judicial office fills out her term, her successor is selected under Article 6 by a nonpartisan judicial election. If, however, she fails to complete her term, whether through resignation, death, or removal, her successor must be appointed by the governor under the clear and unequivocal constitutional terms of Article 6. Floyd's response brief attempts to cast certain hypothetical applications of these provisions as leading to absurd results. The fact is that it is petitioners' atextual remedy in search of a non-existent problem that would lead to absurd and asinine results. Because of petitioners' alleged frustration at when Judge Annis's successor was appointed, she would have this court create, by judicial fiat, a remedy that the people have expressly rejected in their adoption of the applicable Article 6 provisions. Judge Annis's resignation was effective in February of 2020. There was the May 2020 nonpartisan general election, which was ultimately held due to the pandemic and the declared election emergency in June of 2020. The scheduled date and the actual held date was less than months from the time that Judge Annis's resignation was effective. Even assuming that there had been 6 months from the time of Judge Annis's resignation until the nonpartisan general election was held, it would still avail Ms. Floyd, because the operative date is not determined by the effective date of the resignation, but by the effective date of the appointment. We solely make the argument about the effective date of the resignation to point out the absurdity of Floyd's contention that it was somehow a scheme or construct of Governor Kemp to avoid a judicial election that has led to Judge Stone not having to stand until May of 2022. It is a matter of temporal necessity and constitutional prescription as to why Judge Stone will not stand for election until May of 2022. If Floyd was frustrated by Governor Kemp's alleged delay in appointing Judge Annis's successor, there was a opportunity available to her to bring a mandamus and argue that the appointment could be compelled through mandamus in a time certain. I think that Floyd would have had a very high burden to overcome to argue that the constitutional terms impose any sort of time constraints on when the governor could appoint. I will also point out the fallacy of petitioner's argument. She makes the allegation that Governor Kemp could avoid ever having his appointee not having to stand for election by simply delaying the appointment. The only way that could actually happen is for Governor Kemp never to fill the vacancy. So at that point, not only would you have a mandamus option available to you to try to compel Kemp to make an appointment, but there would be no question that an appointee was holding over longer than they were otherwise authorized to do under the Article 6 terms, because the appointment would never have been made. It is basically a hollow argument, Your Honor, but it's the best that the petitioner has come up with. So I feel it necessary to address basically the complete absence of any meritorious substance therein.
So can I stop you for a second?
Go ahead.
The part about the 6-month rule and the application of it, specifically in this case where the appointment of Judge Stone was, I believe it was February I forgot the day. It's February of 2020, correct? Or whatever day in the month it was.
You're talking about Judge Annis's resignation effective date, or
no,
Judge?
Judge Stone's appointment was, I'm sorry, was February of 2021. Correct.
Yes, Your Honor.
So what I'm trying to think about is the 6-month rule and the application of the nonpartisan, we used to call the nonpartisan primary.
Right.
Yeah, I guess it's referred to as a general election, but doesn't the constitutional provision in the 6-month rule application refer to the general election?
It does, Your Honor, but as the court in Barrow held, that now takes place in May. What the General Assembly did was do away with, I believe you have run at least once before you took senior status under the old system. It was the proverbial cattle call at the nonpartisan general primary, which at that point was held, I think, in July, before we moved it forward to May. And then the nonpartisan general election, where whoever won the nonpartisan primary would stand unopposed in November. As the court said, that's all basically, in effect, a usufruct now. It's no longer applicable. We have set a nonpartisan general election to be held in May of even numbered years. And that is the general election for nonpartisan offices. There is no nonpartisan office holder that appears on November ballot. I'm sorry, Your Honor, what?
The constitutional requirement is referring to the nonpartisan general election, which is now held in May. That's your point?
That's correct, Your Honor, as interpreted by this court or by the Georgia Supreme Court in the Barrow decision.
Okay. I'm sorry, go ahead with your argument.
Thank you, Your Honor. I will say, if this court were to consider the atextual argument advanced by petitioner and issue an order setting aside Judge Stone's valid and constitutionally required appointment, then Judge Stone's supporters would at that point have an argument in federal court that the state had violated the dictates laid out in Duncan v. Poitras, because you would have a situation where a judicial office holder was being selected in an atextual manner, not authorized under the Constitution, because the only method of filling the vacancy created by Judge Annis's resignation is by gubernatorial appointment. And to order that a special election be held deviates from the constitutional text. Palmore, Heisel, Clark, Barrow all compel dismissal of this action based on their clear direction as to how to interpret Article 6. As the Georgia Supreme Court has repeatedly stated, the Hooper decision, which petitioner relies on extensively, no longer is applicable to judicial officers. Gonzalez, relied on by Floyd, repeatedly distinguishes the process for filling judicial vacancies from the methodology for filling other vacancies, including the district attorney position that was at issue in Gonzalez. The Article 6 provisions are clear, as are the relevant Georgia Supreme Court cases, that Judge Stone's appointment was not only authorized, but required by the plain language of the Constitution. Accordingly, we renew our motion to dismiss, or in the alternative, deny Floyd's petition for the grounds raised in our prior briefing, as well as the arguments made here today. And if the court doesn't have any questions, I will the remainder of any time that I have for rebuttal.
All right, Mr. Rhodes.
Thank you, Your Honor. May it please the court, Joe Rhodes and Sam Emis for the petitioner, Miss Maureen Floyd. First, I just want to jump in and talk directly about the actual language of Article 6. It does not say must. It says shall. It says vacancies shall be filled by appointment. It does not say must. As I'm sure the court is aware, shall leaves a lot of room. It is not the same as must. Shall, as decided by the Court of Appeals and Supreme Court, is basically can be filled by appointment, not must be filled by appointment. So that is not the text that the Attorney General's office is. That's not the correct text that the Attorney General's office keeps reciting. First, I'd like to talk to the court about the leave to file quo warranto. We found information for leave, and that actually has been granted as of this date. All that is required to have an appropriate petition for quo warranto.
The leave to file was granted?
It was not. It has not been granted, and so that's why I wanted to discuss that first.
It was granted.
No, it has not been granted, and so all that is required for leave to be granted is that the petition must direct its inquiry to the holder of a public office that's not otherwise free of inquiry, that not otherwise is not subject to quo warranto. Well, Superior Court judges are subject to quo warranto, and there's a bunch of cases on them. And then the other prong is that the petitioner must have a genuine interest in said office. The petitioner is a practitioner of law in the very geographical area of which the respondent is now a presiding justice.
I don't think there's any question about her standing to bring this action. The Attorney General's never argued against that, so that's not really an issue. She's got a right to bring it.
If the court doesn't think that's an issue, then we humbly request the court to grant leave to file as quickly as possible, because that's all that's required for the leave to file to be granted.
But it's also discretionary.
Yes, Your Honor, it is. But I believe we've met the burden for leave to be granted. Secondly, I'd like to draw the court's attention to in the brief, the Attorney General makes reference that the petition cannot be amended. It absolutely can. The case on point is Anderson v. Flake. It's 480 Southwest 2nd, 1997. And it clearly says that the CPA applies and that any petition for quo warranto can be amended.
Did you say Southwest 2nd?
480 Southeast 2nd, 10.
I heard Southwest. I was wondering about that. Okay.
Or in the alternative, Your Honor, 267 Georgia 498.
I don't think the Attorney General has argued that it can't be amended either. I think he referred to the fact that it was amended a couple of times.
Okay. It is in their response brief, Your Honor.
Okay.
And so I just wanted to bring those to the court's attention.
All right.
Okay. What we've had here is a situation where a vacancy occurred, and the governor, who under Barrow now, the term of the incumbent ceases. There's no term to fill anymore. The term ceases, and a new term for a new person begins. And how that term, the length of that term, depends on it's the position of the Attorney General of when the appointment is made. Now, the governor chose not to appoint anybody for over a year, and in effect abolished a legislatively created judicial seat. And should the governor continue to be granted that authority, he can indefinitely postpone his duty to appoint judges and then truly abolish a judicial seat that's created by the legislature and infringing on the separation of powers. we give the legislature the ability to create judgeships and the executive branch the ability to fill judgeships. And if the executive branch fails to do their duty, then there is no, it abolishes what the legislative branch has done. Without any penalty for that, our checks and balances system fails, and we've given the governor the ability to abolish a judicial seat. And in the Augusta Judicial Circuit, that's exactly what it felt like for at least a year. As I talked about the interpretation of the text earlier, in that it actually says shall and not must. There's another constitutional provision that governs what the governor must do, and that's he must fill vacancies promptly. And that's in Article 5, Section 2, Paragraph 8. I don't think over a year delay in filling a vacancy could be considered promptly by any stretch. It just can't. The synonyms for promptly are timely, seasonably, or reasonably, and over a year delay fails to meet that definition. And the governor violated Article 5 when he failed to make that appointment for over a year. So what we have is a judge that is sitting in violation of the Constitution. Just a second, Your Honor. I'm going to let my associate Sam Emis speak.
Here's the other secondary issue, Your Honor. So under the Constitution, where it refers to the 6-month rule that respondent refers to, it speaks to the election. So at the time that this constitutional provision came into effect, that election was November. So if we use that 6-month timeline and base it off of November, 6 months therefrom would be in May 2020. So had the governor promptly appointed Jesse Stone or anyone to fill the vacancy created by the resignation of Judge Annis, then that person's term of office under the Constitution would have been until December 31st, 2020, and they would have had to run in the election. By delaying this appointment and not doing it promptly, that term of office is extended until December 2022, and they would run in the election in 2022. So the issue isn't just that whether the governor has the authority to make this appointment, it's by delaying that appointment, has he unlawfully extended the term of office for that appointee, circumvented the 2020 election, which that appointee would have had to run in, and therefore extended that term to 2022 and made it so that that appointee runs in 2022 rather than 2020. So the issue is when we look at the other appointments that the governor has made between the time of the notice of resignation until back in 2020 until the actual filling of the vacancy in 2021, as you saw in our brief, there were dozens of appointments made for both Superior Court, appellate, and senior judges. And in fact, Judge Annis,
Let me stop for a second. I want to ask you about the first part of the argument about the extending the term, as you put it. If the resignation was effective in February of 2020, and if the governor had made an appointment the next day, would Judge Stone have been required to run in the primary election? I guess it's the nonpartisan election that would have been in May but was extended to June. Would he have been required to run in that election?
So what we argue is yes, because either then or November, the idea is that you have to measure that 6 months based on the term election in the Constitution. And the Constitution, when that term election was made, refers to November. Now, what respondent is trying to argue is, well, it's not November, it's May or June. But that is not what it meant when the Constitution took effect, and to argue that the statute moving the election date changes that timeline under the Constitution, I don't think is proper to allow the legislature to effectively get around this timeline without going through the proper process, which would be a constitutional amendment.
So you're arguing that every sitting judge in the state, in the Superior Court, the Court of Appeals, and the Supreme Court is elected unlawfully because they were all elected in the election in May or June of 2020.
No, we're not arguing that.
I'll be elected in November.
No, we're not arguing that. What we're saying is that the timeline in terms of the appointee should be measured from November, because that is what that meant at the time of the creation of the Constitution and when it took effect. Not that the elections must be had then, but that is what that meant then. And to get around that through a statute rather than a constitutional amendment effectively changes the term of office of these appointees.
The other question that I have is that it seems to me that everything you're arguing is the deficiencies, if you will, of the governor. That the governor failed to do this and the governor failed to do that in a timely fashion. Why is your remedy, if you get your remedy and the court were to find that Judge Stone is not entitled to hold the office, wouldn't the governor then have the right to turn around and make another appointment to fill a vacancy? I mean, you got what you're complaining about, which was an appointment, whether it was tardy or not, he did it. And now you're complaining about it. And if you win, don't you get a new appointment?
Your Honor, it's our position that no, you don't. That the governor, like I said at the beginning of this, Article 6 says that vacancies shall be appointed by the governor. That shall is not a word of command. It is not must. It is not the only way in which judges can be appointed. The governor has waived his ability to make the appointment. He has waited over a year to make the appointment, and he has waived that ability. In the Constitution,
why didn't you file a mandamus against him 6 months later?
Say that again, Your Honor.
I'm sorry, Judge.
Well, if a year went by, really more than a year, if you consider when he received the resignation, it was, what would have been about 14 months. After 6 months of no appointment, when other appointments had been made, as you noted, your entire complaint to me seems to be against the governor. Why did you not file a mandamus against the governor?
Well, essentially, that's getting to what respondent may argue is, well, this issue is moot. You should have filed a writ of mandamus. It's too late. Well, the relief isn't just to have a judge, but it's the process with which that judge is selected. And the relief would be a special election. And if
hold it, and show me where in a quo warranto proceeding, which is a special statutory proceeding, where you get equitable relief that would authorize the court to order a special election.
It wouldn't be through the quo warranto. It would be once the leave for quo warranto is granted, and then there is the vacancy of that office. Then you file the writ of mandamus against the Secretary of State to compel him to hold a special election for this open position of judgeship.
Where's the authority for the Secretary of State to hold a special election?
Could you say it one more time?
We can't hear you.
Where's the authority of the Secretary of State to hold a special election for a judicial office? Has there ever been one?
It happens. It would. The Constitution says Superior Court judges can be may come into office in two ways. One is vacancies shall be appointed by the governor, and two is qualified individuals shall be elected. And so the Constitution gives the state the ability to hold an election to elect a qualified candidate.
And we will say, Your Honor, this is a unique issue. We haven't had a situation like this before, where there's been this almost indefinite delay of a judicial appointment. It's a unique situation. It's actually, if you read the dissent in the Barrow opinion, specifically, this was something that they were worried about happening. Judge Trammell, it's actually page 95 of the Barrow opinion, said, quote, "What is the result if something happens and the governor does not make an appointment? Again, while improbable, we are discussing the possibilities of this potential appointment and not the probabilities. If the governor did not appoint prior to December 31st, when the Constitution mandates that an elected official shall take office, what happens?" And that very delay, that very gap in the Constitution, which is unique, was a hypothetical envisioned by the dissenting opinion in Barrow and has now happened in this case. So that's why we're going to the court, to resolve this gap, to figure it out, and to seek this injunctive relief to allow the people to select this judge who should take office, rather than having the governor circumvent the election that should have been had.
The Superior Court has equitable powers, and nothing in the quo warranto statute strips the equitable powers of Superior Court away.
Well, I think if you read the cases, you'll see that when quo warranto is available, that there is no equitable jurisdiction, because quo warranto is an action at law. You get, if you win, you get relief. You can't. I don't think you can mix quo warranto and equity.
May I have a quick moment to speak to my co-counsel?
Sure.
So it's not.
Yeah, Your Honor, what my co-counsel was relaying to me was, well, we can't seek equitable relief without first having quo warranto. So if we went and sought equitable relief, it would just be dismissed because we didn't have the proper standing to do so. And so this is a necessary part of the process.
Okay. Go ahead and finish your argument then.
Say that again, Your Honor. I didn't hear.
Go ahead and can finish up with your argument.
Well, Your Honor, in sum, if quo warranto isn't granted, then the governor has now been granted the ability to abolish judicial seats. He can simply choose, I don't have to appoint, I'm not going to, and hold that out indefinitely, and steal the ability to abolish judicial seats from the legislature. It's not a great feeling, especially when you're the ones that live there.
And if I may, the question I would ask respondent, and I think this is the position they're taking, is how long does the governor have to make this appointment? Is it indefinite? Can he wait forever? Can he wait
But you're
until
acting as if there's no remedy. I mean, you're proposing that the governor can simply never appoint and that you're left without a remedy. But that's not true, is it? Isn't mandamus a remedy for that?
And it would be, once we are granted petition, once the quo warranto action is completed and there's the vacancy in the office, then we file the writ of mandamus against the Secretary of State to compel the special election.
No, not against the Secretary of State, against the governor.
Against the governor of the state of Georgia.
He's playing politics with the appointments. He's timing it so that whoever he wants to appoint doesn't have to stand for election for 3 years or however long it might be, or never appoints anybody. Isn't mandamus a warranty? I mean, a remedy for that?
So there will be twofold. One, it's the mandamus to compel the governor to make the prompt appointment. But two, when failing to make the prompt appointment such that the later appointee has circumvented the election, one would say that then the mandamus is to compel that election. That should have been had had the governor promptly appointed that appointee.
The people shouldn't be forced to file mandamus actions to do what the governor is required to do under the Constitution, to fill appointments promptly. They shouldn't have to file mandamus actions to stop him from abolishing judicial seats that are created by the legislature. And even if a mandamus action was available earlier, that does not foreclose the ability to do one now. If quo warranto is granted, and we can subsequently file mandamus, that still provides relief, even if the court thinks that there was some relief available earlier. That doesn't foreclose the ability for petitioner to seek relief now.
Okay. Anything else?
That's all, Your Honor.
Any response, Mr. Willard?
Yes, Your Honor, I'll try to keep it brief. They want desperately for the court to grant them leave to file the quo warranto so that they can proceed with the quo warranto. As we indicated when we had the initial hearing on this matter, we don't believe it's appropriate, and we have cited to case law, which is unrefuted by a petitioner, that the motion to dismiss is an appropriate vehicle to inquire into the legitimacy of a petition for leave to file quo warranto. The cites for that authority are Walker v. Hamilton, 209 Georgia 735, and Anderson versus Flake, 270 Georgia 141. Interestingly, the Anderson decision, which upheld the grant of summary judgment in a petition for quo warranto, had been preceded by a Supreme Court decision just 1 year prior that had reversed the trial court's dismissal. But they reversed the trial court's dismissal of the petition for leave, not because they said that that was not authorized or an appropriate vehicle. The sole basis for reversal by the Supreme Court was they said that the petitioners had alleged potential issues of disputed facts that needed more factual inquiry before resolution. And we don't have that. Both sides have conceded that we're only talking about legal issues. There are no disputed factual issues. So a motion to dismiss is quite appropriate at this stage. If you don't want to classify it as a dismissal, you can just deny based on all the arguments that we've raised.
Let me ask one thing that just is not clear about in the nonpartisan election that was held in June of last year. Was this seat was not on the ballot in that election, was it?
That is correct, Your Honor.
Did anybody attempt to qualify for that? Do you know?
No, Your Honor. I'm not aware of anyone attempting to qualify with my client, Secretary of State. I don't believe that that is anywhere in the record, but that election was held after the court's decision in Barrow. And I bring Barrow up at this point, Your Honor, because I would point you to the Penn site of 308 Georgia at 669. And there you have a fulsome discussion by the Georgia Supreme Court, or at least the majority in the Barrow decision, not the two-judge that petitioner wants to wrap herself in, where they discuss the differences on the ground in terms of what the applicable general election is and when it is held. And the court goes into great length to talk about, while the Constitution, when it was adopted in 1983, extraneous facts, i.e. when the General Assembly had set the nonpartisan general election was to occur in November of each year. The law had changed, as the Barrow Court recognized, and to applicable general election date now is the May general nonpartisan May nonpartisan general election. That is the applicable election which you count back the 6 months from. So at this point, if an appointment is made anytime after December of an odd numbered year, that person does not have to stand for election until May of the next even numbered year. They attempt, I won't even say they make, to make hay out of the adverb promptly in terms of the governor's duty to appoint to fill judicial vacancies. As Your Honor, I think, is rightly recognized, that goes to a potential action against the governor compelling him to make appointments in a more timely fashion. It does nothing to delegitimize a valid appointment made to a judicial office, such as has occurred here. If the General Assembly, none of whom are parties to this action, had a how the governor was fulfilling his constitutional obligation to fill judicial vacancies, or thought that by executive inaction, the governor was negating something that had been done by enacted law, the General Assembly has options available to it. They can bring a mandamus action seeking to compel the executive branch to act. They haven't done it. Or if they believe that there is a gap in the constitutional paradigm that the current governor is exploiting at the time, they have a remedy unique to the General Assembly. They can propose to change the constitutional provisions. They have not done so, but they can do so if they disagree with the executive branch on other issues. And they have done that. I'm sure Your Honor followed with interest the fact that former Governor Deal and current Governor Kemp had vetoed a series of legislative actions attempting to legislatively waive certain aspects of sovereign immunity. Rather than attempting to override those gubernatorial vetoes, the General Assembly proposed a constitutional amendment. It ended up being ratified by the people in question 2 in the November 2020 general election, and it changed the provisions of Article 1 in regards to the applicability of sovereign immunity. That hasn't occurred at this point. And it's because the governor is doing exactly what he is authorized and required to do under Article 6. And if the petitioner truly believes that there is a governor who would choose to wait until they stand for election in a general election and leave a judicial vacancy to their successor in office should they be defeated or should their term expire, then I think they display a naivete regarding the political interest of anyone who holds the office of governor. They are going to fill every vacancy that they can. There may be delays in filling a particular vacancy due to certain circumstances, such as last year, the existence of a global pandemic, where you had a governor who I am sure was balancing the needs of trying to maintain state functions during that pandemic, as well as protect the public's health and welfare. And so I can't speak to where on the priority list filling a Superior Court vacancy for the Augusta Judicial Circuit may have fallen. But I can say that before any action was filed against him, the governor did discharge his duty to fill that vacancy by the appointment of Judge Stone. And petitioners advanced no argument that would merit setting that appointment aside. If the court has no additional questions, I think the respondent has amply demonstrated that the court should dismiss this petition or in the alternative, deny leave to file the quo warranto.
All right, Mr. Rhodes, one last crack at it.
Thank you, Your Honor. I first want to address the statements made regarding the General Assembly's actions. They're not a part of this case, and frankly, I don't think any of that is relevant to the matter at hand. Secondly, I'd like to address the comment about the governor was busy. We've shown very well how easy it was for the governor to make appointments. We filed with the court all of his other judicial appointments he made during this year-long period. I want to make a comment about factual issues. Your Honor, at the beginning of this hearing, made some opening statements. The facts surrounding some of those have changed. At the time we had the pretrial or the scheduling conference, we had not amended our petition. We have since amended our petition and included a claim that calls into the question that the promptness that the governor is required to appoint or fill vacancies. We have cited case law in our briefs that show that what is prompt is a question of fact. And so there very well may be a question. We may have to determine what a question of fact is, what promptness is under these circumstances. And that would also avoid a motion to dismiss, as a question of fact would be outstanding as to whether Judge Stone's appointment was prompt and as such constitutional. Sam, do you have any additional?
The only, if I may, Your Honor.
Yes.
With respect to respondent's position in terms of the possible reason for the delay being the COVID pandemic, which had occurred during the year 2020 and is still going on, as we had put in our amended petition in our brief in support thereof, there had been several appointments made between the notice of resignation by Judge Annis and the appointment of Jesse Stone to fill that vacancy. In fact, on the day in which Jesse Stone was appointed to fill that vacancy, which was February 22nd, 2021, there were 3 other appointments made for Superior Court judges in Georgia. And the appointment of Jesse Stone is the only one of those 3 where that 6 months from the date in which that office was vacated. And so in terms of this unique inconsistency, in fact, it was the only one we found that there was this more than year-long delay between the date the office was vacated and the date an appointment was filled for that vacancy, is evidence that with respect to this case, the governor did not promptly exercise his constitutional authority. And that is a central issue here.
Your Honor, I'm assuming it's my motion, I get the last word until the court speaks.
Sure.
I just want to address, they are attempting, they've engaged in a little game of pleading whack-a-mole after the court had entered its pretrial order, setting the briefing schedule and making substantive rulings in terms of the temporal issues. They've attempted to file 2 amended petitions at this point. To some of the same extent, they're attempting to just delay the dismissal of their complaint today, arguing that there are factual issues still outstanding. I will say my response to their entire argument about promptly is a red herring. It has no legal consequence regarding the legitimacy of Judge Stone to hold the appointment. It may very well be an issue if someone were to bring a mandamus action against a who they alleged was being recalcitrant in making their appointments under Article 6. But once that appointment is made, the adverb promptly, as it applies to gubernatorial duty, has no bearing on Judge Stone's ability to hold the office. And with that, we think the matter is ripe for dismissal at this point.
All right, very well. I will be working on an order, and you can expect to see it probably by the end of next week.
Thank you, Your Honor.
So
Thank you,
something
Judge.
else, we'll be in recess. Ms. Brackett, thank you for being available for this, and Sergeant Jones, thank you for getting it all set up. We're now in recess.
Thank you, Judge.